On supplementary list, item number
If I
1.
may crave your lordship's indulgence to make a mention, my lords. There's an urgent matter concerning, my lords, there will be some difficulty because it's an order passed by my lords. Yes. We'll make a mention in the other bench, my lords.
Yes.
Yes. My apologies.
On supplementary list, item number 1.
This is a PIL concerning the Balat Road, my lords.
Which road?
There is a certain road, my lords, which leads to the border areas of Meghalaya. The area is called Balat.
I think there is similar repetitions of pending.
Similar repetitions, but with regard to different areas, my lords,
Yes.
not particular. Can be tagged along with those other matters.
We can take it as for the repairing the roads, is it not?
Lordships.
So see, publicly it can be widened.
Lord.
There is no need for separate repetition anyhow. Let it come with that. Give the number.
We'll give the number of minutes to the court master. Obliged.
Number 2.
Admit post on phone.
My lord, I have filed the report, my lord, of the study tour of the Paro International Airport.
On the
My lord, item number 2.
Some other.
I'm sorry.
Yes, sir.
Item number 2, my lord, WPC 269 of 24.
Yes.
I appear for the petitioner, my lord.
What is the matter about?
My lord, the matter is, it's a customs matter wherein the adjudication order is against the rules annexed as Annexure A15, A16, my lord. There is an undue haste. In fact, the rules clearly say there are to be 3 notices sent in sufficient intervals. In fact, the second and the third notices are sent on the same day, my lord. They are annexed as Annexures 14 and 15.
Take notice.
My lord, they've come against an adjudication order, my lord. There's an appellate remedy under that.
Where is
No,
the
my
post?
lord, this is
Section 129 of the Customs Act, my lord.
No. Where is the order?
Well, the order is in the last annexure, my lord, starting from page 129.
my lord, we are questioning it on natural justice grounds, and it's clearly against rules. My lordship may kindly see annexures 14 and 15.
Page number.
Page number, my lord, 93. 93.
93.
93. 93 of the writ petition.
This is the show cause notice.
No. 93, my lord, 93, 94, and 95 are the notice and the postal receipts. Your lordship will see on page 95, the postal receipt reads it was sent on 7/6/2024. The postal receipt, my lord.
7.
7/6/2024 at 12:31.
12/6.
7/6/2024 at 12:31. That was the second notice sent.
1 minute, sir.
Yes.
Where is it? 12:31. 7/6/12:31.
Yes. That's the second notice, second hearing notice, my lord. Now the third hearing notice is available. The postal receipt is available on page 98, which is also sent on the same day.
What do you say?
My lord, whatever, if there is any irregularity, my lord,
Clear principle.
they can raise this.
Supreme Court has categorically held that alternative remedy, if available, cannot be bypassed. But there is a clear violation. How you are sending 2 notices on the same day? How do you say 3 notices have been complied with?
My lord, this is also against the rules. The rules, as in page 111, I have annexed the rules issued by the Ministry of Finance for adjudication. 117, page 117 of the writ petition. This is the master circular for adjudication issued by the Central Board of Indirect Taxes and Customs.
117.
117. Last
Personal
portion.
hearing.
Yeah, last portion. In fact, it is the fourth line from the bottom. In fact, separate letter for each hearing / extension should be issued at sufficient interval. The fourth line from the bottom.
I'll file affidavit. I'll file affidavit.
You ascertain, if that is the case, they'll interfere with the order and give them the specified date. On the day, let them appear.
Well,
No, my
We'll
lord,
post
no
it.
coercive actions. My lord, no coercive actions may be taken on the adjudication order, my lord.
Wait, so.
Yes.
this is order of 21st June. There's no question of any coercive action as well.
No. We'll settle the order, give them an opportunity, finish it within a period of 1 month. You get instructions
On Friday.
on Friday.
Well,
We'll pass
In
on
the
this.
meantime, no coercive actions may be taken, my lord.
Sir, Friday, nothing is going to happen before Friday, sir. Yes. Post on Friday. Dr. Moshika takes notice, post on Friday. The only thing you ensure whether it's the same notice or different notice,
well,
or different items you ascertain.
well.
If it is the same thing, we'll satisfy the order, give them an opportunity, and we'll say that this is the final opportunity given to him as per orders of the court. And he'll appear and you pass orders after hearing the person hearing the party in person.
Right.
Because if you see that page, personal hearing should also be given. Pass order.
Obliged. Obliged.
Yes.
Item number 3.
Lords, there is a delay of 12 days.
Delay of?
12 days, my lords.
Which on the other side?
I'm there, Your Lordship, but they are private respondent, Your Lordship.
Private respondents are
Lordship,
notice. Notice.
Lordship.
Returnable by. Date given. Private
Yes.
notice also permitted. Yes. Private notice to the private respondents. He says non-pleader takes notice for so and so response. Yes.
Apply, Your Lordship.
Item number 4.
Your Lordship, there is a delay of 121 days, my lord.
Yes. Also,
376, my lord.
376.
370.
376 too.
Yes, my lord.
No, delay condoned. No objection, delay condoned. What's the matter for admission?
Bench, my lord.
Post it tomorrow. Admission tomorrow. Admission tomorrow.
Item number 5.
This one. What is the matter?
May it pleases your lordship. Lordship, this is the matter relating to the old pension regime
Oh,
and the
correct,
new
correct.
pension
You heard.
regime, your lordship.
You heard the matter.
Lordship.
Did they dictate to you? Not it started. There's one recent judgment of Punjab Haryana is also there. Recent judgment of Punjab Haryana, I think public newspaper on 27th July or 26th July
I'll find out.
reflected.
We'll find
I
out.
want a copy of the judgment.
We'll find out, your lordship. That is not my notice.
Saying that a person who was joined earlier, now here a question of
But
regulatory.
the fact here, your lordship, the fact here is, your lordship, they were admitted fact, your lordship, they were regularized, your lordship, post 2010, your lordship.
That is right. You have regularized. For
Lordship,
the service is rendered, what happened?
lordship, the advertisement, your lordship, is only for ad hoc, your lordship. Ad hoc, they accepted willingly, your lordship, the terms and conditions of the service, your lordship. Matter may kindly be admitted, your lordship.
So this is, we have already heard. I will pass final orders. On Friday, I'll pass final orders. I'll dictate it on 15th.
Lordship,
I heard both of you.
15.
15 holiday.
Not 15th, 16th. I'll pass.
Your Lordship also had the occasion to pass a similar judgment when your Lordship was sitting then. That's in item number 6 in my summary of submission. The list of books is already given. Judgment and order dated 30th June 2022. I have given a full text of the judgment also, Your Lordship.
State of Tamil Nadu.
State of Tamil Nadu. This judgment was authored by your lordship. Page number 8.
You want a full judgment on page number 8? You see that
In the extracts of judgment, your lordship.
Lordship, this
In the extracts of
the
judgment.
authorities which my friend had relied, lordship, were not given us a copy also.
Give a copy.
Lordship, just now only you have received, lordship, put up one tree.
We'll call it tomorrow. You read it and the address.
Much obliged.
Post tomorrow. Whatever what you want to say, may submit. I'll try to pass orders.
Lordship, apply.
Send the papers. Send the papers home for me to read.
Apply, lordship.
Papers home to read.
Item number 2.
Need please yourself.
Yes.
My lords, I have filed the reports. If I may draw my lords to very quickly to page 8. Page number 8 of the reports, my lord. The few observations and recommendations which may be considered, my lord.
Number 8.
May I read, my lord, from the number 1. The optical surface limitation of Paro Airport is less than 500 meters towards the northeast direction, and towards the southwest direction is about 3.2 kilometers, with mountains elevating as high as 18,000 feet, while the final obstacles of Omroi Airport is almost nil comparing to Paro. Therefore, possibility of landing mid-size aircraft cannot be ruled out at Omroi Airport. This is one, my lord. Second, Paro International Airport is situated at an elevation of 7,700 feet above the sea level, with a runway length of about 2265 meters or 7431 feet long, whereas the Omroi Airport is situated at an elevation of about 29110 feet above sea level, with a runway length of 6,000 feet, which is just about 1,000 feet less than the Paro International Airport. It is learned that the higher the altitude, the more challenging is landing. And since Omroi Airport is located at elevation of about 2265, the runway of 6,000 feet long is ideal for mid-size aircraft. Number 3, that with regard to the apprehension of commercial viabilities, there is possibility of thinking of hopping flight, say for example Omroi to Guwahati or Kolkata and to various destinations. It is to be noted that Imphal, Aizawl, Dibrugarh, Agartala, Silchar operates hopping flights to Guwahati and to other destinations. Therefore, if other airports can operate, Omroi cannot be an exceptional one. Number 4, the Omroi Airport has got more advantages than the Paro International Airport because it is fitted with instrument landing system for a period of low visibility, and it is also learned that there is no restriction for the airports to set up with instrument landings from permitting visual system of operation. Therefore, Omroi Airport can operate both modes of operation, my lord. I have attached some of the photographs, my lord, out of the visitation, my lord.
In fact, the airport there was designed
by Airports Authority of India.
Indians.
Yes, my lord. By the Indians.
Have you mentioned it?
My lord, that I have mentioned at the earlier.
It is there. It is there, my lord.
My entire reports, my lord, it is mentioned.
Where is that?
Introduction, my lord, page 2, page 1, my lord. Introduction is there. And historical context and development, my lord.
So they don't develop the value of Paro Airport.
Indian border, initially.
My lord, 1984, page 3, my lord, the government built a small terminal with modern like departure scrutiny and actually this.
Page number 2, you have stated.
My lord. So the BROs.
After 1 year and 5 months, it was completed Indian border routes. I think runway appears to be very, not only small,
My lord.
the breadth is also very less.
Yes, my lord. And if you, my lord, page number 4, my lord. My lord will see the last one, runway width, my lord. The runway is 30 meters only, my lord. Which is 98 feet wide.
Yes.
Of course, I have not mentioned that the hills, just from the ends of the parallel ends of the runway, my lord, if you, there's a hill, my lord, and there's a mountain, which is 50 meters. And at one point of time, there's a big hill, which comes to less than 45 meters, my lord, from the runway, from the parallel runway, my lord. And even the, yes, my lord, and some photographs which I have mentioned.
So give a copy to the other side.
Yes, my lord.
I've received a copy.
I have received the copy, my lord, and we have also
My lord,
seen
you
the
have to file a reply to this, my lord. I'm praying for some time to file a reply to this report, my lord. My lord, what is the most important part in this report, my lord? The Umrah airport, my lord, is in Meghalaya, where most of the time in the rainy season, in monsoon season, we have clouds, my lord. And the visibility is very low, my lord. My lord, before the ILS was installed in this airport, my lord, after the filing of this PIL, earlier, most of the time the flight used to come from Calcutta had to return because of low visibility, my lord. Now, only because of ILS, the flights are landing regularly, my lord. Now, the difficulty, my lord, is that for ILS, there are international rules and regulations that because the margin of error has to be very wide, my lord.
Which should be wide?
Instrument landing requires very large margin.
Not only instrumental landing, but also visual landing is there. Both are there.
My lord, there can be only one thing, my lord. Either because in visual landing, my lord, the pilot uses his expertise, his techniques, my lord, to the landing. There he has the margin of error can be much less, my lord, in case of visual landing. But the difficulty with visual landing in Umrah is that there's a foggy conditions in most of the rainy season.
I think in also they operate during daytime, not
daytime.
No flight, night flights.
Because it is visual landing airport, my lord. Because if I'm
Which
explaining,
is visual landing?
always visual landing, my lord.
Not only visual, but all the instrument is also there. They are using instruments.
My lord, it is mentioned here, my lord, in the report what has been given to me that the absence of instrument landing system adds to the challenge at page 5, my lord. The report itself says, my lord.
Page number?
Page number 5, my lord. Navigational challenges. If I must come to 5th line, my lord. The absence of instrument landing system adds to the challenge.
What is it?
While 5th line,
Unlike a conventional airport, Paro lacks radar assistance, accompanying the pilots also non-control. Strict procedure adopted decision is on.
next sentence says the absence of instrument landing system adds to the challenge.
My lord, page 6, my lord.
The instrument is also there.
My lord, page 6, my lord, they have developed an instrument known as AR cloud breaking. Page 6, my lord, page 6. Page 6 of the report, to enhance safety and instrument flight procedure known as RNP AR cloud breaking is applied for an Airbus subsidiaries, my lord.
Where are you reading?
Page 6, my lord,
Page
the
6,
first line,
so
the first line.
Having?
The first line itself.
First
my
line
lord.
now.
Yes, my lord.
So,
So, my lord,
see, instrument was also there.
My lord, I do not know, my lord. I read from the report. My
Instrument
lord.
landing system, the ILS they are not using, my lord. ILS they are not using.
And second aspect, my lord. My lord, the second most important, which is equally crucial aspect, my lord, at page 6, your lordship will see, in first para, the last sentence, my lord. Nevertheless, Paro allows takeoffs and approaches in both directions, unlike Umrah Airport.
Correct.
It's
Correct.
possible.
So,
Yes.
the distance between the northern end and southern end is only from the hill,
Yes.
bottom of the hill to the runway end, it's only 500 meters.
Yes.
They allow both
Sites.
landing and taking off on both sides. They allow.
So, which is not possible.
Here, compared to that place, the hill is big here.
Yes.
My lord, in fact, in the previous report which is submitted in this PIL, my lord, the hills on the other side is very high, my lord.
Where?
On the other side of the.
We are not. It's not true. We are not going to say, or the authority. We are not going to say. Authority will have to remove a portion of the hill and permit the aircraft to operate both sides. That is not possible. With the existing one, whether the mid-size aircraft should see, what they do is they take limited passengers with full fuel,
My lord.
or with 50% or 60% of the fuel, more passengers, and the nearest airport they land.
My lord. For refueling.
Thereafter, they fill up the fuel, and other passengers board in the flight, and it goes to Singapore, Bangkok, and other places.
Yes.
Unless you have the instrumental landing, it will be not possible. No, why should they send a flight to? Why should they fly to Singapore and Bangkok?
Yes.
My lord, what I'll do, my lord, because the airport authority wants to file a reply to this report, my lord. That's one. And the LIDAR survey report is still under examination, my lord.
That is right. You give the LIDAR survey report. That's not a problem at all. See, you must understand, Mr. Mushika,
My lord.
that we have to pass orders before Friday on the report. We'll file a report. Thereafter you file a LIDAR report. If there is any contravention or contradiction, my brother is there and he can take further decision on the matter.
My lord.
My lord may also direct, my
In
lord.
fact, both of us were inside with the pilot.
Oh, yes.
Near half an hour, we were able to see how it was landing.
My lord may.
In fact, it's an international flight.
Yes.
We were allowed to sit there.
In fact, in Ladakh, what I remember,
Nobody will be allowed.
even in Ladakh, you also had a
Yes.
word with the
No,
pilot
yes.
after landing.
Exactly. But after landing, but here we were allowed to sit and see the land.
While landing.
We saw, yes, while flying. There only I found. Bhutan people trust everybody. We suspect everybody.
Yes.
That is a basic problem.
So on Friday, my lord? Lots of
No, we'll go through it. We'll call it tomorrow. Then thereafter, whatever is
My
possible.
lord, may also consider, my lord, because learned senior is saying that wherever there is an instrument landing system, the visual is not possible, is not allowed. To that effect, let the responsibility officer file, because after interactions, I'm very convinced that is also by an officers of the airports authority saying that it is possible.
Your officers were also there. They were fully convinced
Yes.
that it can be operated. Ultimately, from here, we can't say have the airport here. You allow 320 to fly land, 319 to land. We can't say that. Ultimately, you have to take a decision.
My lord, what I pray that let the airport authority examine this report also, my lord. In the meantime, they'll have a LIDAR survey report also. So let them come out with an affidavit, final affidavit. So what are the possibilities and how they want to?
We'll call the matter tomorrow. We'll also go through the report. And if anything is there, we'll render our views
Yes.
on the report. And thereafter, we are not going to conclude dispose of the writ petition. It's going to be pending.
My-
We'll see. So, you also send this also to my residents.
Apply.
Item number 3.
The last 2 days I thought, no, without any work I should be free. Now the number of cases.
Matters.
Apply.
Only thing is my PA. I'm not saying we should not type this order in another case, that order in this case.
Apply.
Yes.
Deeply.
Item number 3.
Yes. What is this?
This is Maithindu River pollution, my lord. Maithindu River pollution.
My lord, kindly, I have filed an first observation interim report, my lord.
I will be requesting your lordship may take up this matter tomorrow because don't have the copy of my micas, my lord.
65.
Oh, my lord, tomorrow.
Give them a
Then.
copy.
I'll give them copy, my lord.
The request of the Advocate General post the matter tomorrow.
All right.
Tomorrow or Friday?
Friday, my lord. Your lordship may have it Friday.
Friday.
I will be in person assisting your lordship.
My lord. All right.
Item number 4.
This also. Sir.
Your Lordship, this is a application
Delay.
for continuation.
Where is this?
Actually, as per the last order, notice is to be issued to the respondents. We've already filed.
Served.
Yes, Your Lordship.
Where is the proof?
We filed affidavit compliance.
Where? Affidavit of compliance. Yes. Who is going to appear? Who are all the respondents? The private respondent, 2, 4, and 5?
I'm representing only for the state respondent, Your Lordship.
Huh?
I'm representing only for the state respondent.
That is right. Notice have been served. How many days delay?
66, Your Lordship.
56 days.
66.
66 days.
Yes.
Condone the delay. The respondent contesting the so-and-so appearing to the respondent. There's no serious objection for the delay being condoned. Even though the respondent 2, 4 and 5 have been served and proof of service have been filed on 12/8/2024, none represented, and there's no representation. No prejudice is going to be caused to the respondent if the delay is condoned and the main matter is taken upon merits. Delay condoned. Goes for admission. Friday. Tomorrow? Possible? No. Yes.
From the daily list, item number 1.
We gave it. 8 matters. The last matter.
May I please, Your Lordship? So this matter, Lordship, with regard to incorrect date of birth, my Lord, in the service record, my Lord. And I was prematurely released by the respondent authorities, my Lord, on 29/6/2022, my Lord. My Lord, I was appointed in the year 89, my Lord.
1 minute.
Yes, my Lord.
Yes.
Yes, my Lord. My Lord, I was appointed in the year 1988.
You have got rules, it has got to be corrected before
Yes, my
years
Lord. Yes,
of-
my Lord. My Lord, during my service career, the issue was never surfaced. Neither I was, the respondent had issued any notice. Time to time, the respondent authorities had issued a service ID card, wherein my correct date of birth is recorded in the service ID card as well as in the service record. In the service record,
Who's
two.
on the other side? Madam, you are appearing.
Lordship, I'm appearing for the state, my lord.
Take notice.
Lordship.
Take notice. Order of? Brother, no? Justice. Order of justice ding dong. Thank you. What's that? Post the matter on Monday before the division bench consisting of J2 and J3. My order is also there.
Much obliged, Lordship.
My brother and Justice Bhattacharya will hear the matter on Monday.
My Lord.
Yes.
Item number
Deeply
2.
obliged.
From supplementary list, item number 1.
No, just.
Well, it's
Mr. Paul
a your
wanted-
lordship's indulgence to make a mention for listing of a matter, my lords, it's a fresh matter. An appeal, my lords, passed by the learned single judge. In a matter, my lords, where I am not a party, some orders have been passed regarding an inquiry by the district council, my lords.
You take a chance on Monday.
Uh,
Nothing is going to happen. You take a chance on Monday.
my lords.
Yes.
Item number 1.
Oh, this is the gratuity matter.
Madam.
Yes. Yes.
Yeah, ma'am. Wait, please. I would just like to take to a brief factual background.
Yes.
Madam, I would just like to take to a brief factual background of the matter. Because since it pertains to the...
That is we have understood the case.
My lord, okay. So, my lord, the only thing is
We
now
know that originally went to the controlling authority, got favorable order, it was reviewed.
My lord.
Then thereafter, a writ petition was filed.
My lord.
Got a order.
My lord.
Then it appealed.
My lord.
Thereafter, Supreme Court. Before the Supreme Court, you considered to pay the money.
My lord.
You received it. Now we are seeking the interest on the amount.
My lord.
According to them, there was not only a delay in approaching the authority,
My lord.
which we don't know, but anyway, there is a delay in approaching this court. 3 years delay, 2018, 2021 you have come.
My lord. That's to
Correct.
some extent because,
And,
because of the COVID.
Suppose you come after 5 or 10 years.
My lord.
In terms of 7, 3 and 8,
My
you'll be getting 100% interest
My lord.
because the principal amount as gratuity.
Yes.
That has got to be reduced. We'll see.
So, my lord, our contention is basically when we were made to retire on the golden handshake scheme in the year 2004.
So there are two ways of looking at it, sir.
My lord.
If they don't pay the gratuity, right is given to you to approach the controlling authority.
My lord. My lord.
Right? According to you, there is a statutory duty caused upon them,
Yes, ma'am.
and the entire section 7 has got to be read together,
Yes.
and harmonious reading should be given
My lord.
for the purpose of granting you interest.
My lord.
Correct? So in which case you will be entitled to gratuity.
My lord.
When was it? When was the golden handshake?
Golden handshake scheme was it was in the year 2004.
2004.
31st August 2004, we were made to retire.
So now 20 years have gone by.
So, my lord, on principle, the day on which I was made to retire on the basis of the golden handshake scheme, the payment of gratuity ought to have been paid.
That is right.
My-
20 years have gone by.
My,
So there is a delay in approaching the authority,
my,
delay in approaching the court.
my lord,
Correct?
my lord.
So,
Delay, my lord,
not delay in approaching authority, delay in approaching the court.
my lord.
Delay in approaching the court. Correct?
So, my lord, so far we are concerned, we were, there was no delay on our part.
No. The order of a single judge says
My lord.
there is a delay. Remember, correct? See the last paragraph or last but one paragraph. Paragraph 23.
My lord. My lord,
Paragraph 23.
yes.
See, till I write a judgment, I will not forget. Once I write the judgment, I will forget the case.
Because the only thing is that at the first instance, when this scheme was mooted out on the based on the cabinet memorandum,
Sir,
we
you must understand one thing.
My lord.
We agree with you the gratuity is not a gratis or bounty
Yes,
or what you are entitled to. You refer to the judgment of the Kerala High Court. And
My
these are, one judge. Supreme Court has referred to that.
Yes, madam.
All those things are there. See, our question is, see, take for example, Industrial Disputes Act, 1947.
Madam.
You can raise an industrial dispute any point of time.
Madam.
Then the 2010, sometime on 15th September or 16th September 2010, ID Act got amended, stating that the dispute has got to be raised within a period of 3 years, similar to the civil CPC, limitation period. Here, there is no limitation prescribed as such given, except that you have to approach the court within a period of authority within 30 days or 90 days, 60 days, that is how it has been given, appropriate remedy and all. But authority is empowered to condone. Whereas if you go to the civil court or under the ID Act, after 3 years, it's barred. In this case, you have approached the court only in 2021. More so after receiving the gratuity amount in 2018.
My lord.
18 last one. 19, some 19 also.
Some of them have received on 19 also. My lord, our contention, basic contention is this, that at the first time when this golden handles scheme was muted, it was mooted out, there were some grey areas. So there were some grey areas, so we had filed repetitions. Repetition was filed, and it is reflected in the repetition.
If that is the case, everybody will, the authority, see, general stand with the authority has got to condone the delay. Whether it's 100 days or 1000 days, authority will condone the delay. Whether interest should be deprived for the 1000 days or 100 days is a point. Even assuming that 100 days is deprived or 1000 days is deprived, if the litigation is going to continue for another 5 or 10 years, automatically you are going to get the entire gratuity principal amount as interest in terms of section 8. And the purpose itself is you will be entitled to. But how much you are entitled to only we'll have to see.
Our contention is
that's all. We'll pass orders.
My lord, I have only one objections, my lord. My objections, my lord, and I support, my lord, the judgment, the impugned judgment under challenge, my lord. Page 23, paragraph 23, my lord, of the judgment of the learned single of his lordship, very clearly says, my lord. 23 of the impugned judgment, page 246, my lord. Page 246.
Page
246, my lord.
Page, yes.
Here, my lord, his lordship has said, even if the above is found not tenable, the other factor that has to be considered is that during the hearing of the matter before the High Court or even before the Supreme Court, the petitioners have not made any prayer for grant of interest on any alleged delay payment of gratuity. After having received the amount of gratuity in the year 2018, the petitioners have approached this court with a prayer for grant of such interest only in the year 2021, without any explanation of why.
We have read.
Yes,
we
yes.
have read.
So, my lord, in this to support this,
so on the ground of latches, writ petition will have to be dismissed.
My lord, my lord.
And Learned Single was right in dismissing the writ petition.
Yes,
so we have to confirm with that. So
yes,
point. Then other point.
That is a point, my lord. And to support this, my lord, I am referring to Supreme Court 2024 judgment, my lord. Give me a copy, my lord. Two copies.
Give me a copy.
Yes, my lord. The relevant portion, my paragraphs, paragraph 9, paragraph 11, my lord. These two are the paragraphs, my lord. May I read, my lord?
With regard to approaching the court.
My lord.
Delay. Yes.
Yes, my lord.
Supporting that.
And this is and another one is, my lord, of 2023 SEC online. SEC online, my lord. This The entire, my lord, this judgment shows the analysis, reasoning, and conclusions of the delay lectures.
Which is cited?
2023 SEC online.
You were given.
Yes, my lord. Yes, my lord. That is also given, my lord. And I am
23.
2023 SEC online. SEC online. It's my lord is with me. 23. Why now? This one. I'm relying on paragraph. Paragraph 21 onwards, my lord. Till the end, my lord.
2023 SEC online. Supreme Court 1307.
Yes, sir. Yes, my lord. So I'm relying from paragraph 21 onwards, my lord, in this judgment, my lord, to support the
21.
Yes, my lord, 21 onwards, my lord. This is on the same low point of delay in laches acquiescence, my lord.
Hey, read the judgment of the Supreme Court.
Yes, my lord.
In
So,
the Constitution bench. 2000. Remember that. Suddenly I'm not able to. Jaipur Zilla. What is the citation that I gave? 2002, volume 2 SEC, page 244, para 13. Take the judgment. Page 2002, volume 2, Supreme Court cases. I think 244, para 13. Get the judgment.
which SEC online.
It's a Constitution bench judgment.
My lord.
Where they say none of the provisions of the statute should go redundant. Then it becomes so that you must give a harmonious, a constructive meaning has got to be given.
My lord, that would be correct, my lord. But if the litigant sleeps over his right, my lord, then, my lord, there are judgment which says that the fundamental right cannot be waived off, but the statutory rights can be waived off, my lord.
One thing you must understand: it's a gratuity,
My lord.
pension,
Yes, my lord.
are all property.
My lord.
So, in terms of Article 301(2) of the Constitution of India,
Yes.
you cannot
Deny.
take away the property right, except in accordance with law.
My lord.
Anyway, we'll see.
My lord,
But we will not give. See, we are going to give some relief.
my lord, I
We are
have
going, definitely not 100%.
correct. My lord, I have a judgment. I have also supplied. If I may be allowed to read, because this judgment clearly reveals as to the facts of the case, which is very close. Supreme Court, that is 2020. I have supplied it. If I may be just allowed.
Supreme Court 2000.
Volume 3 SCT. Keval Singh Prasad versus Punjab Agricultural University.
This is citation, sir.
This citation is that 2020 Volume 3 SCT. It's,
You are given.
yes, ma'am, I have given. Decided on 2nd January 2019. Keval Singh Prasad versus
1 minute, sir. This one. 2020.
Madam.
2020 is 3 SCT 638.
Madam. If I may be just allowed to read.
What is this is judgment of Supreme Court. Yeah.
Madam. Haryana and Punjab Agricultural University, clause 9(1)(1), entitlement for interest on delay payment of pension, gratuity, and provident fund. As the committee had recommended earlier in favor of the appellant that he is entitled to count the past service, the university ought to have counted the service to release the benefit. However, he was dragged into litigation, even otherwise provided provident fund carries interest.
You are entitled to interest, sir, no doubt about it.
Yes. But the
Have you knocked at the court well within time? That is his point.
My lord, but this judgment says, in this judgment, the relevant part, in para 4, my lord.
What is your case now?
My case is this, I am claiming.
You want 100% interest. Is that your case?
Yes, my lord. From year 2000.
We are not going to give.
When I am entitled.
We are not going
because at that point of time, when I was made to ask my leave.
No, we are trying. Your friend is citing one judgment in which I was a party in Madras High Court, where I said gratuity need not be paid. I am trying to distinguish the judgment on a different aspect, which I have just before you commence the argument, I started writing it, saying how it should be distinguished. So when I have to take a different view of my judgment, I will have to give a review, saying that the judgment will not be applicable here. So leave alone the other Supreme Court other judgments. My judgment is there against you. So I will have to distinguish it and see how much can be given. Otherwise, everybody will come after 20 years or 30 years and say that the entire principle.
That is true, but the fact remains that
2002 2 SEC 244, para number 13, if I remember correct, should be para number 13. It is well settled rule of interpretation that no part of the statute shall be construed as unnecessary or superfluous. The proviso cannot be diluted or disobeyed by an employer. He cannot disobey the mandatory provision and then contend that the order is void or inoperative. He cannot be permitted to take advantage of his own wrong. The interpretation, very important, is next line. The interpretation of a statute must be such that it should advance the legislative intent and serve the purpose for which it has been made rather than frustrate it. That is what it says, Supreme Court says. Anyway, we are not going to give you the entire relief. If you still argue, we will reduce the percentage. We will give you, definitely. We'll definitely give you. In fact, I have already dictated the judgment. Only conclusion alone is there. Before I forget, I thought I should dictate.
My lord, only one point, my lord, just want to reiterate myself, my lord. We stand by saying that we have not delayed because we have complied with the order directions of the Honorable Supreme Court. Order said pay within 30 days.
The gratuity
Yes.
is inclusive of interest is going to be addressed. That is the only issue.
Yes, my lord.
We will say that's one aspect. We are going to say that is inclusive of interest has got to be paid. But we are going to deprive him interest because he has approached the court belatedly.
My lord.
And that it is not a gratis or bounty.
Yes.
We are reducing. The court is empowered to reduce it.
Yes, my lord.
See, in one case, Supreme Court has granted 18%.
My lord, in this
They say 141.
My lord, the only aspect is that who is culpable in the delay in dragging us to litigation.
Supreme Court alone can say this is correct or that is correct, not correct. See, if you take the Marriage Act, irretrievable breakdown of marriage is not at all there. Supreme Court has granted in many cases. I had an occasion to meet Justice Sirpurkar in Bhopal conference. I asked him, when such a provision is not there, then the order of Justice Garju is correct. What do you say? Is it all the cases are decided here? 141, we gave relief. That was his answer. See, it was not, Supreme Court, suppose we say something or we write something at all, they criticize the judges, the High Court. But the problem is not there. Now it is not there, previously it was there. Till Friday, I can't say anything. On Saturday, I can say anything. Because Justice V.R. Kashay said when there are 25 Supreme Court judges, don't think that there is one Supreme Court in India. There are 25 Supreme Courts. That was his statement. See, we are able to see one judgment delivered by Supreme Court is contrary to another judgment. And in 1997, in Ramachandra Rao, some case, we have a general manager telecom case. Bangalore water supply case was interfered by the two judges. Three judges write in that 1997 judgment, page 797 or not, I think it starts on the right hand side, SCC book, on the right hand side page. On the left hand side, if you read it, the Supreme Court says, criticizing the other judges, saying that judicial discipline requires the larger bench judgment should be followed by a smaller bench. So these are things are there. In some cases, you don't know, one person supports NEET at one stage, the same person opposes the NEET on the other side after some time. These things happens. Your state people itself will here. State power, your advocate, I'm saying Meghalaya advocate itself there. Only supports the NEET is opposing NEET now. So these things, as a lawyer you can say anything. That because development of law and different judgments are coming. See, that is why, whenever we want to deliver a judgment, my brother judge, I think, the cultural aspect of the state has got to be taken into account.
Sure.
You go abroad, live abroad and come back, and then you take those views here, apply that, is not possible.
Sure.
So certain things which has got to be carefully considered. That's why, in one of my farewell speech, I have made it one sentence, which I am saying now. When case is on trial, case is tried, judge is on trial. Judges are on trial. We are being tried. And similarly, Delhi High Court judge said, both parties know what is the truth. We are here to find which is truth. Anyhow, I'll give you some relief. Don't worry, not entire relief.
I'm sorry to bother your lordships. That's indicated that we take a chance on Monday. Well, it's what I'm instructed by my learned friends are. There would be some difficulty post Monday because Honorable Justice Thank You has recused himself in this matter, and the orders passed by Justice Lindo. So, there is no quorum available post Friday. Would your lordships kindly indulge us on Friday, subject to the order of the
Not possible. Not possible. Anyhow, list it on Friday, we'll see.
Well, I'm grateful.
List it on Friday.
Right.